Hello, Doctor. Have a good day ahead. Let me introduce myself first. My name is Shree Udaykumar, matron number 269521. Today, I'm as a group leader going to discuss about the group assignment 1 which has been done by our group members Keshini, Keshavartini, Rupasri, Navina Sinha and I myself. The group assignment title is Land as a Bank Collateral. In this assignment, we will discuss about introduction of the land as a bank collateral, problem statement, literature review, legal analysis, and also recommendation and conclusion of this assignment. Let's have a look on the next slide. Thank you. Hello, Doctor. My name is CHARVINI Udaykumar, matron number 269521. Today, I'm going to present on my part, which is introduction. In this part, I'm going to present about the definition of bank collateral and also land. Bank collateral is some issues deposit as a guarantee of the project or loan. If the borrower fails to repay the loan, then the lender can seal the safety to get back the loan. Security is obtained as a line of the final defense to get again the loan quantity. By taking security, bank acquire, declare our right assets over the borrower. In reimbursement is not made as a regular with time desk. Moreover, the most vital capabilities of the bank is to make investment its fund through a way of the loans and advance to its clients, and financial group energy relies upon significantly on the speed of its loan and advances. Land. Land can be used and frequent as a security for a loan because of its special attributes as an immovable property which could deliver upward push to several pursuit in the choice of several ladies and men at the equal time. Land is eternal, durable, and its rate is no way out of place. Maximum of all can confer interest to diverse human beings at the identical time because of its appear as a safety. Throughout, the banks are sincerely anticipated to provide greater emphasis at the cost for which the borrower needs coins as an opposite safety he can manage to pay for the offer. Safe remains one of the maximum critical factors which determine to the big extent the banker's willingness for the cash. Next, 1.2 Background of research. Our research recognizes is in banking collateral safety. First of all, collateral banking is a vital prudential and present defense in opposition to credit chance and default chance. The Malay Reservation Enactment of 1913 and the Land Enactment of 1987 shaped the Malay Reserve Land. Malay Reserve Land has a key provision that Malay Reserve Land cannot be transferred to non-Malays each via sales or lease. Under Financial Service Act 2013, all banks and monetary establishments its need to normally take some collateral for any credit score facilities given to their clients. In this assignment, purposely research about issues on the indefensibility of title and also regarding limitation acts. So, in the current slide, we will look on the objective of the research. The first objective of the research is to study very detailed about bank collateral under banking law. Second is to understand about land as a bank collateral in Malaysia. Third, to study about how to deal a land as a secured loan in banking institution and also the impact that it's create on the bank and also their customers. Thank you.
Have a good day, Doctor. I'm Keshavatini Murli, matrix number 269590, and I'll be talking about problem statement. The advancement in a really nation, without a doubt, will gotten to be more noteworthy from year to year. But the occasion made each and every time will fetch numerous arrive to be utilized. The address now is that arrive considered as a bank collateral and what can be the issues. In a few cases, money lenders will permit to put up a chunk of arrive as collateral for a secured credit. Not all moneylenders acknowledge arrive as collateral, and indeed individuals who do would require that the arrive be worth a particular sum so as to think approximately is to be utilized as a collateral. The banks moreover will require that we are the proprietor of the arrive we would like to utilize as collateral. Most moneylenders won't credit to borrowers who need to utilize arrive that has a place to vary one individual as collateral. To secure an advance utilizing our property as collateral, we must discover a bank to basically acknowledge our arrive as collateral. Once we have distinguished fitting moneylenders, we must decide what quantity money we would like to borrow, and in the event that our arrive is a viable sufficient to operate collateral. Once we have distinguished fitting banks, we must decide what amount cash we would like to borrow, and on the off chance that our arrive is compelling sufficient to operate collateral for the amount we wish to borrow. Once we all know the amount of cash our bank will loan us supported our arrive, we'll need to total the advance prepared. The loan specialist too will audit the arrived deed to test for any existing liens or obligation which can be joined. In case other lien exists as of now on the property, the moneylender probably would acknowledge the arrive as collateral. In spite of the fact that numerous of those things about are from the 1980s, it is apparent that the scene of collateral-based loaning has not changed much. Early studies from country zones uncover that arrive is kept as a last resort for borrowing and is fair utilized as a collateral in cases of crisis. The essential step toward utilizing moneylenders at the point evaluate and compare their advance terms and conditions. The essential choice isn't continuously the right choice when it involves selecting our favorite moneylender. Continuously make beyond any doubt that we find the foremost successful conceivable terms which incorporate critical parameters like integrate rates and length of reimbursement that coordinate our needs. Secured advance strategy a credit or progress made on the security of property the commercial center cost of which isn't at any time boundary but the sum of such advance or broadened. Collateral comprehensive of arrive required to scale back degree of threat in contract repayment. Thank you.
Hi everyone, have a good day. I'm Nana here, one of the group member of Group 4. Now, I'm going to be available a straightforward video presentation dependent on my part, which is based on the literature review, which is I'm done based on the issue of lands as a bank collateral. Let's we have a first look on what is the collateral actually. Collateral is defining a future of a loan contract together with a interest rate, maturity, size, and possible covenants. Drawing from current theories, collateral helps bank to solve two main problems. The first one is collateral can limit banks' losses in the case of default by liquidating the collateral. The second one is collateral can solve the problem of asymmetric information between banks and the borrowers arising when borrowers own private information that is not available to banks. High-quality borrowers who have private information about their good creditworthiness know that the chance of default on the loan and the loss of their collateral are unlikely. Therefore, the high-quality borrowers are more willing to pledge collateral in compensation of more favorable contract terms than low-quality borrowers. Hence, collateral helps reduce adverse selection by signaling, which is stated by Stiglitz and Weiss in 1981, Bester in 1985, Chan and Kanadas in 1985, and also Besanko and Taco in 1987 in some articles. The borrowers can choose their preferred contract for themselves, and by choosing high collateral, they signal their status as high-quality borrowers. The second is collateral helps solve the problem of moral hazard after the loan is granted, which is stated in a journal by Good-Thakor and Udall in 1991. In general, theories that view collateral as a solution to the asymmetric information problem predict a negative relation between presence of collateral and the borrower's risk level, both ex ante and ex post. More importantly and contradictory to the arguments of the asymmetric information theories, there is a common view among bankers that collateral is associated with riskier borrowers, which was said by Berger and Udall in 1990, Jimenez and Zaurina 2004, Indust and Muller 2006 in particular journals. Since collateral helps to reduce the loss in case of default, bank would require more collateral from borrowers with higher default risk. This is commonly called the observed risk hypothesis. In general, theories that view collateral as a solution to the asymmetric information problem predict a negative relation between presence of collateral and the borrower's risk level, both ex ante and ex post. More importantly and contradictory to the arguments of the asymmetric information theories, there is a common view among bankers that collateral is associated with riskier borrowers, which was said by Berger and Udall in 1990, Jimenez and Zaurina 2004, Indust and Muller 2006 in particular journals. Since collateral helps to reduce the loss in case of default, bank would require more collateral from borrowers with higher default risk. This is commonly called the observed risk hypothesis. Okay, now let me to give a short and simple introduction based on the land property. The development in country surely will become greater from year to year, but the development made each and every time will cost many land to be used. So there were some policy has been made in order to managing the land. Same goes to Malaysia development system. The development system in Malaysia will be also related to the policy of land administration. As can be seen in Malaysia, the main act that referring to the land administration was the National Land Code, which is known as NLC. The NLC has been established on year 1965 and also has been called as Act 95. There are also legislations enacted at the state level, such as the various Malay reservation enactments. Based on a journal written by Zainal in 2014, he said that the land administration and land law practices in Malaysia are based on the torrent system introduced by the British. Okay, now let's we move to see the use of land as a collateral. The loan can act as a powerful form of collateral if we need to acquire a secure loan. Not all lenders accept land as collateral, and even those who do will require that the land be worth a certain amount in order to consider it for use as a collateral. Depending on the size of a loan people need, as well as their prior borrowing history, they might be required to use something as substantial as property to secure the funding they require. Most lenders will not loan to borrowers who want to use land that belongs to more than one person as collateral. Fortunately, the act of listing their land as collateral can be accomplished without much hassle. Once the value of their land has been assessed by a qualified expert, they can begin the process of transforming their property holdings into qualified collateral, which is stated in Cockerham in 2019 journal. Apart from that, there are some issues arise when the land acts as collateral. The first one is finding the right lender. Based on a journal written by Cockerham in 2019, he says that although land historical has been considered a qualified form of a collateral, people might discover that particular lenders are more receptive to this idea than others. With that in mind, the first step toward using land as collateral is to identify a series of compatible lenders, then assess and compare their loan terms and conditions. Remember that the first choice is not always the right choice when it comes to selecting preferred lender. Always ensure that find the best possible terms which include important parameters such as interest rates and length of repayment that match people's needs. Next is identifying the value of property. If people intend on using their land as collateral, the next step is to determine precisely how much their land is worth. Given the wide variety of factors that can influence the value of their land holdings, it is quite possible that an appraisal will be required before they execute their loan. This is also stated by Cockerham in 2019 in a journal. To do this, they will need to hire a professional appraiser who has been approved by the lender they have selected. Once the value of their land has been finalized, their lender will be able to provide them with loan terms that they can either accept or reject as they see fit. The last but not least is secure a loan with collateral. To secure a loan using people's property as collateral, they will need to find a lender willing to accept their land as collateral. Once they have identified appropriate lenders, they must determine how much money they need to borrow and if their land is valuable enough to serve as collateral for the amount they wish to borrow. Once they know the amount of money their lender will lend them based on their land, they will need to complete their loan process. This will involve showing proof of ownership of the land they wish they use as collateral to prove that they are free to use the land. If the true value of the land is unknown, the lender may need to hire a licensed third-party real estate appraiser. This is usually necessary when the property in question is potentially valued at 50,000 or more, which is said by the Bischoff in a journal in 2019. Likewise, if the loan is valued over 250,000, the appraisal may need to be certified to make sure it is accurate. The lender will also review the land deed to check for any existing liens or debts that may be attached. That's all from me. Thank you.
I'm Keshi Tanabalu. My matching number is 280006. Now I will present the legal analysis on the issues of land as bank collateral. Our team have identified 4 issues regarding land as collateral for securing bank loans. The issues are regarding whether Malay reserve land can be charged to a non-Malay person or institution, issues on banks' right under absolute assignment, issues about indefeasibility of title, and the last issue was about the Limitation Act and the auction dates. The first issue is regarding the Malay reserve land, whether it can be charged to a non-Malay bank. Malay reserve land was formed by the Malay Reservation Enactment of 1913 and the Land Enactment of 1987. There are basic legal principles regarding Malay Reserve land, which are any dealings, be it transfer, lease, or charge of Malay Reserve land, must only be in favor of a person who is Malay or any institution qualified as Malay under the enactment. Thus, in Malaysia, non-Malay person or non-Malay institution cannot be charged with a Malay Reserve land. Otherwise, it would be rendered null and void, except in Kedah. This can be looked through the case of Affin Bank Berhad versus Jamaluddin bin Jafar. In this case, the appellant has charged a Malay Reserve land in Kedah that belongs to Jamaluddin bin Jafar as the collateral for its loan to Affin Bank. Affin Bank received a judgment in default after the loan was defaulted on, and then submitted a bankruptcy petition and obtained a bankruptcy order against Jamaluddin. Jamaluddin filed a motion against this petition stating that the charged land is a Malay Reserve land, and according to Section 6 of the Kedah Malay Reservation Enactment number 63, it can only charge to a Malay person or institution. Now, the big question was whether the Malay Reserve land can be charged to Affin Bank, a non-Malay bank under Section 6 of the Kedah Enactment. On this case, the High Court dismissed Jamaluddin's petition and judged in favor of Affin Bank. When this case went to an appeal, the judgment of Court of Appeal clashed with the previous judgment. Thus, this case reached the Federal Court, and the Federal Court reinstated the High Court's decision and disagreed with the judgment of Court of Appeal. The Federal Court referred to Section 6(1) of the enactment. The court stated that the terms "no right" or "interest therein shall vest" are specified in Section 6(1) of the enactment by the words "whether by transfer, sale at the instance of a chargee, sale in execution of a degree, or otherwise." The court also referred to Schedule A of the enactment, which states that all documents of ownership, excluding surat account, banci sewa, and permits, may be charged to anyone, but if the charger does not pay the money due the land, if owned by a Malay, may be sold only to a Malay. This means that the land can be charged to a non-Malay as long as the land's rights are not transferred to a non-Malay. Now, what about other states? As previously said, a non-Malay cannot be charged with a Malay Reserve land other than in Kedah. Moving on to the next issue, bank's right under absolute assignment. Absolute assignment defined as the transfer of the ownership completely to the other party without any terms or conditions. Now, the question is, does a bank has rights to sell land under an absolute assignment? It can be examined through the case of Damai Freight and Sendirian Berhad versus Affin Bank Berhad. According to this case, Perbadanan Kemajuan Negeri Selangor (PKNS) bought a land from the Selangor state government. PKNS entered into a lease agreement with the appellant, Damai Freight and Sendirian Berhad. While waiting for the title document to the land to be released, the appellant obtained loans from Bank Bureau Malaysia Berhad (BBMB) under a loan contract with assignment, which required the appellant to transfer all of its right, title, and the interest under the principal contract to BBMB. Following that, BBMB transferred its business and assets to the respondent, Affin Bank Berhad, including the loan agreement. This case went to court to determine whether a bank has its right under an absolute assignment after the Land Office has issued a title document. The High Court ruled in favor of the appellant, Damai Freight and Sendirian Berhad, that the bank had to establish a charge over the land before releasing its protection under an absolute assignment since the title document had been released. This ruling was reversed by the Court of Appeal. Thus, this case went to the Federal Court. The Federal Court upheld the ruling of the Court of Appeal and appeal was dismissed. Even though no charge was made, it was held that the bank had secured all of the borrower's rights, title, and interest under an absolute assignment. Furthermore, despite the fact that the title document was released later, the bank did not lose its protection or power of sale under the loan agreement because the absolute assignment under the agreement survived. As a result, the bank had the right to sell the land to recover its compensation for the loans. There was no need to create a charge or use any of the National Land Code's remedies. Furthermore, the issues regarding land as collateral is indefeasibility of title. A registered title to or interest in the land can be considered defeasible and set aside as outlined in Section 340 of the National Land Code. In the meantime, Section 340 of the National Land Code states that a prior registered title to or interest in land which is obtained from a previous holder of registered title or owner of registered interest who enters the register using several of the contractual methods mentioned in Section 340 of the National Land Code is secured if the subsequent registered title to or interest in land is purchased in good faith for good cause. The Federal Court recently had the opportunity to examine and review the concept of good faith in Section 340 of the National Land Code in the case of T. Sivam Analalaki Dharamalingam versus Public Bank Berhad. The conflict was about the claims on the same piece of land between the actual registered owner of the land and a chargee bank because of a third party's fraud. The primary issue was whether the chargee bank's registered interest will be secured under the proviso to Section 340 of the National Land Code. In this case, T. Sivam was the registered owner of an agricultural land. His land was fraudulently transferred to one of his sons. The son secured a loan from a bank after being registered as the owner of the property, and a charge over the land was made and registered in favor of the bank as collateral for the loan. T. Sivam eventually found about the fraudulent transfer of his land as well as about the charge formation. Then he filed separate legal proceedings to set aside the legal transfer and the charge. In his motion, he stated that the charge was defeasible and invalid because it was created after the fraudulent transfer. The High Court later set aside the transfer because, according to the proviso of Section 340 of the National Land Code, the chargee bank could not demand protection as the bank was an immediate acquirer or holder of interest in good faith. The Court of Appeal overturned the High Court's ruling in response to the chargee bank's appeal. According to the Court of Appeal, the charging bank was a subsequent acquirer of the land in good faith for valuable consideration. Thus, the chargee bank can benefit from the protection under the proviso of Section 340 of the National Land Code as the chargee bank was unaware of the alleged fraudulent transfer of the land. The charge was then set aside by the Federal Court, which concluded that the bank did not obtain the interest in the land in good faith because the solicitor's awareness of fraud must be imputed to the chargee bank when working for the chargee bank in making and registering the charge, and then the transfer of land to the son and the loan transaction were instantly subsequent to one another and were quite closely related. Thus, the first transaction must be still in the solicitor's mind and he should discover that there was a fraud. The Federal Court's ruling reflects the prevailing legal situations on the sense of good faith under Section 340 of the National Land Code's proviso. As a result, when obtaining title to or an interest in property, an acquirer of title to or interest in land must act honestly and take all necessary precautions. Keeping in mind that the solicitor's expertise is known by law as the client's knowledge, and it's best to hire a lawyer who hasn't had any prior contract with the property. The final issue was on land as bank collateral is about the Limitation Act and the auction dates. When someone takes a loan to secure their loan with a piece of land, then the bank can apply for an order for sale to sell off the land to pay off their debt if the borrower doesn't pay back the loan. Now, the issue is about what will happen if the banks are unable to complete the sale after several attempts. Is it necessary for the bank to accomplish the auction within a certain time period? This can be analyzed through the case of RHB Bank Berhad versus Dato Haji Muhammad Hamzah. On this case, Dato Haji Muhammad Hamzah received a land from Bank Utama Berhad to fund a purchase of land. Dato Haji Hamzah was eventually unable to repay the debt. No action was taken against Dato Haji Hamzah, and the situation remained unchanged until RHB Bank Berhad acquired Bank Utama. Following that, Bank Utama agreed to pursue Dato Haji Hamzah for repayment of the loan. This was accomplished through a legislative demand in 1999 and an originating summons in 2001, where RHB was successful in obtaining an order for sale against Dato Haji Hamzah's land in 2002. Several attempts to sell off the land were made, but none of them were successful, as the auctions were either cancelled due to a lack of the bidders or cancelled due to Dato Haji Hamzah's various applications to stop the auction from continuing. After RHB tried to get a new date in 2017, Dato Haji Hamzah filed a motion to stop RHB from auctioning the land again, recover any debts owed to RHB, or implement the charge against him, claiming that the limitation period of 12 years under Section 21 of the Limitation Act had run out, effectively prohibiting any further proceedings. The High Court dismissed Dato Haji Hamzah's case, stating that the last date RHB obtained in 2017 was simply to issue a new auction date, and that the law of limitation would only apply if RHB was filing for a new action, such as getting an order for sale or starting proceedings against Dato Haji Hamzah for its inability to repay the debt. When this case went to the Court of Appeal, the court disagreed with the previous ruling. The Court of Appeal stated that an auction is an activity as specified under Section 2 of the Limitation Act, and hence it is subject to the 12-year restriction imposed by the Act. In any situation, even the petition was not barred by the aforementioned prohibition. The court noted that it would be barred by Section 6 of the Act, which states, among other things, that an action on a judgment may not be pursued after the expiration of 12 years from the date on which the verdict became enforceable. On the appeal to the Federal Court overturned the Court of Appeal's decision and upheld the decision of the High Court. According to the Federal Court, the petition by RHB to set a new auction date was merely implementing the existing procedures to perform a judgment, and it was not a new action, and hence the Act did not apply. Moreover, the Federal Court also stated that since an order for sale is not a verdict, it is not subject to the Act's Section 6 law. This is because the court hearing the petition for an order for sale does not rule on any important issues, and the debt owed to the bank by Dato Haji Hamzah is not a judgment debt. From this case, we can know that there is no time period to accomplish an auction. Thus, it is not necessary for a bank to complete the sale within a limited time period. That's all from me.
A very good day. My name is Rupa Shriyana Propan Mohan and my matrix number is 271155. I will be presenting recommendations and conclusion. We have recognized the issues of land as bank collateral in this assignment. From the borrower's point of view, the borrower ought to have clear title and should have the ability to reimburse the credit against land, which will in general be of higher worth. The borrower ought to have the option to enroll the home loan and have the choice of abandoning the credit. From the bank's point of view, tolerating land as insurance ought to have either suggest higher sureness of reimbursement given how important land is to the borrower, or then again have the option to adapt the security should the borrower default. In addition, the exchange's cost of offering and tolerating land as guarantee for advances should be low sufficient comparative with the credit size. In a financial setting like Malaysia, every one of these conditions requires critical strategy exertion. While there have been amazing endeavors in few territories, it very well may be some time before the conditions are helpful for families, particularly those with restricted enduring property, to utilize land as security to raise profitable capital. As such, the undertaking of growing proper account will require looking past land as security. All in all, land can go about as an incredible type of guarantee on the chance that you need to get credit. Contingent upon the size of credit you need, just as earlier acquiring history, you may be needed to utilize something as considerable as property to get the subsiding you require. There are numerous benefits in utilizing land as bank insurance. For example, there is a set of interest for land, there is no stockpile of land, and this can be expended in secret ahead of time. Incomes are generally authoritative and long-haul esteem appreciation. Thank you.